This is Business LO, a podcast by the Lake Oswego Chamber of Commerce, which connects, educates, advocates, and champions our business community. We have nearly 500 members from international corporations to home-based businesses, and we serve them all. Each episode of Business LO gives insider information to the local business community and the neighbors who support them. And now, let's talk Business LO.
It's a bonus guest-branded Business LO episode with Attorney Anastasia Yu Meisner. We're going to be discussing an important and apparently myth-filled topic of estate planning. And as good old Benny Franklin said, nothing is certain except for death and taxes. And proper estate planning helps quell the inevitable anxiety surrounding both. Let me tell you a little bit about Anastasia Yu Meisner. She's an attorney based here in Lake Oswego for over 25 years. She provides exceptional legal counsel and advice with personalized service. Her focuses are estate planning, administration, and mediation. In her spare time, she also is a pro tem judge for the Washington County Circuit Court, board member of the Lake Oswego Chamber of Commerce, the Oregon Minority Lawyers Association, the OPB Planned Giving Advisory Committee, and the Oregon Women Lawyers Foundation. But wait, there's more. Along with her friend and attorney colleague, Valerie Sasaki, she co-authored the only book on estate planning in Oregon. And she's been voted by her attorney peers as an estate planning super lawyer, a distinction that less than a dozen Oregon estate planners receive each year. And as a reminder, this conversation is for informational purposes only. It is not legal advice. It's a podcast, people, okay? So I'm really excited to talk about the 5 estate planning myths. Okay, Anastasia, let's bust some myths. This one I've heard many times over the years. If I pass without a will, the government gets everything. That's a myth.
Even if we live to 150, we all will pass. But the government likely will not get everything. There is a plan in Oregon for everyone, and we call that the no plan plan. Most people don't like the plan that Oregon has for us, and therefore they want to actually have something in writing. They usually will see an attorney. But if you don't have something in writing, generally the way Oregon's plan is set out is that if you're married, everything will go to your spouse. And if you're not married and you have children, then everything will be divided equally amongst your children. And that's usually what most people want. If you're married and have children from that relationship, then everything will go to your spouse. That's fine too, because the idea is then once that spouse passes away, everything will go to the children from that common relationship. What happens is when you don't have that type of family situation, then it starts to become a problem for many people. For example, blended families. When somebody has a second marriage, then the state of Oregon law says half goes to current spouse and half goes to equally divided amongst children from the first relationship. And that can be very problematic, especially if, for example, a house is titled just in one spouse's name. And I've seen this happen where the surviving spouse is kicked out of the house because there's not enough assets. And the children from the first relationship force the sale of the house, which is a terrible thing to have happen. Or when somebody has no children and they're not married, but they have siblings still alive, and they don't want a particular sibling, like the brother that they hate, and they don't want that brother to get anything. The best thing to do in those situations is, though the government doesn't get everything, it may be that the plan that Oregon has for you is still not the plan that you want.
Myth number 2, a will avoids probate.
Oh, that is a common misconception. I get that a lot, especially when I have somebody, usually it's the children, who come in and their parent has passed away and they want to know about administering their parent's estate. And I tell them, oh, well, we've got to have a probate because they've come in with a will. And the children think, wait a second. I thought we don't have to have probate because we have a will. And it's the exact opposite. A will equals probate. A will is just a document that identifies who will administer the estate, the order of how assets are spent. For example, expenses are paid first, funeral expenses, taxes, attorney's fees, and then distribution, who's to get what items. It does not avoid probate.
Okay, so what is probate then for our listeners who might not know?
So probate, and then we could probably talk about how to avoid probate, is a court-supervised administration of a decedent's estate. Some of those words, court supervision, decedent's estate, when you hear court supervision, think takes a long time. When you hear court as well, think need an attorney, which also equals costs money.
Mm-hmm.
Probate takes some time to start from one end, the beginning, to get to the point of conclusion, which is distribution. It does take money. It takes attorney time, which equals money, can cost more than administering a trust, which I'll talk about in a bit. And it is not the worst thing ever. It's not, as sometimes I will joke, the seventh level of Dante's Inferno. In some ways, it is a known process. It's a well-developed body of law in Oregon, or fairly well-developed, depends on if you're a litigator or not, but it takes time. And it can be annoying and cumbersome and just aggravating for clients when there's an alternative. There's various alternatives to avoid probate. One of those alternatives, what most people have been told they need, but it's very fact specific. And so I don't always advise clients that they need this alternative, but is a vehicle that's commonly used, is a revocable trust. You will hear people talk about, my neighbor said I need a revocable trust, or my neighbor has a revocable trust, or they're a nice vehicle and they're used to avoid probate. There are other techniques to avoid probate as well. There are assets will have the opportunity to name beneficiaries, such as IRAs and insurance policies. There are assets that are co-owned. For example, spouses will own property together as husband and wife, or there will be non-married folks, brothers, sisters, non-married couples who will own property as tenants by the entirety or own bank accounts jointly. There are other ways or there are pay-on-death accounts or transfer-on-death designations on accounts that are ways to avoid probate.
Okay, so myth number 3, I'm not rich. I don't need to think about estate tax.
Rich is relative, right?
Yes.
And we're talking about monetary richness. Mm-hmm. I think I'm very rich in my life. I love my family. I enjoy my life, and I see the beauty of my life all around me. But from a monetary perspective, rich is relative. And in Oregon, rich is different than what we would say rich is from a federal perspective. So let's talk about the worst case scenario from a federal perspective. And this is talking about rich in terms of the state tax, estate tax. And at the federal level, when I say rich, and I'm not talking about the ultra rich, we're not talking about 100 millionaires
right.
or more. We're talking about people with $13,990,000 this year, that type of rich. Folks with $13,990,000 of net worth at the time they pass away in this year, 2025, would not have to pay federal estate tax. That's different than income tax. That's not capital gains tax. Tax that's paid when somebody's estate is more than $13,990,000 in the year 2025. That number may change this year, may stay permanent. We don't know. Someone who every dollar over that $13,990,000 is subject to tax at the federal level. There's a very thin first million over that that's just taxed at 18%, but then it goes up to 40%. So that's a pretty hefty tax. Doesn't take much to get to 40%. It takes a while to get to $13,990,000. Okay, so at the federal level, that's what I say rich. Mm-hmm. Rich in Oregon is much lower, and unfortunately, Oregon is one of a minority of states that have what we call state estate estate level tax. Oregon is one, Washington happens to be the other, but Oregon has the lowest, meaning if you have 1 million, and this is per person, 1 million net worth at the time you pass away, then you don't have to pay Oregon estate tax. But for every dollar over that net million, then it's subject to Oregon estate tax. And that tax is progressive, starting at 10% and goes up to 16%. For example, if you have a $2 million estate and you're a single person, the first million is not exposed to Oregon's estate tax. The next million is. And if we're just using round numbers, and I'm just saying 10%, but it's probably maybe not 10%, but that's a $100,000 tax.
Right. Wow.
So that's painful.
Yeah.
That can be painful. And you happen to live in a beautiful state of Oregon, but you also live in the state with the worst estate tax of the 50 states. When I started practicing 25 years ago, it was 600 or 650,000 was the threshold, both in Oregon and in the federal level. And Oregon has just ticked up a little bit, and I think it stopped around 2010. Federal has gone, I would say, astronomical. Compared to the uber wealthy, ultra rich, it's not astronomical. But Oregon has not budged off that million. I don't think it's going to go anywhere. Depending on where you live in Oregon, even in other parts of the non-Portland metro area, a person can have one home and one retirement account, and they can hit that $1 million easy.
Easy.
It's amazing. And it's an issue that is not going to change. Every legislative cycle, there are bills to try to either eliminate Oregon's estate tax or to raise that exemption amount from $1 million to bring it up. And there are ways to plan to double it, but you need to see an attorney and you need to be married. And I don't suggest people, I joke, well, then get married if you want to double and avoid tax and double your exemption. It's just a joke. Yeah. But you have to take advantage of the opportunity now. I have folks who unfortunately don't do it while they're married. And after somebody has lost capacity or they're not married, you can't do it. So I don't want to scare people and say, see your attorney now. Mm-hmm. But it kind of is, see your attorney now. It's exactly. Better to plan.
Yes.
Rather than do the emergency or the opportunity is lost and pay more later, unfortunately.
Right. Okay. Myth number 4, estate planning is for the wealthy.
Everybody, in my opinion, can use an estate plan. It may not be that they need to think about tax planning, estate planning, but everyone, once they hit 18, can use an estate plan. Everyone can use a power of attorney. They could benefit from a financial power of attorney and a medical power of attorney. And when I say a medical power of attorney, in Oregon, the specific term is an advance directive. Folks' primary health care provider may say, have you filled out an advance directive? And folks may or may not have done it. But if they haven't done it, do it. Or work with their attorney to do it, because sometimes those documents are a bit complicated. Financial power of attorneys, I think many of us have heard of them, but many of us have not done them and do them. And the reason for that is we never know when we might have an issue with incapacity. And if we have a situation where, I call them red flag events, where something happens and we didn't obviously expect them because it's an emergency, then it's better to have those documents in place. If we don't have them in place, then the alternative is to go to court and get a person appointed by the court, and you can betcha that's thousands of dollars, maybe $3,000 to $5,000.
Whoa.
And for certain assets like an IRA, it's common for spouses to say, well, I'm the named beneficiary. It shouldn't be a problem. And that does not work. A spouse cannot direct an IRA to be liquidated. They don't own it. They were not the participant of that asset. If they are not named specifically in a financial power of attorney that, and many times specifically says that they have the power to manage a qualified investment account or an IRA, that institution may not recognize the power of attorney. And, for example, during COVID, it became common for me to work with parents and their college-bound children to prepare both of these documents, because during COVID, some of these college-age children would be diagnosed with COVID, and then the parents would have difficulty helping their children navigate the healthcare process or be able to talk with the doctors to help their children through the process. That was very hard. For young people who, for example, I had a young person who was very into the sport of motocross and being injured and was in the hospital for a long time and did not have a financial power of attorney to help pay bills, or to even talk to the HR department at his employers to help with getting the paycheck or filing for short-term disability through the HR department with their employer. So it is very helpful. Doesn't matter what age you are.
We've got one more, the fifth one. I did my estate plan. I don't need to think about it again.
An estate plan is not like a crock pot. You do not set it and forget it. At minimum, I like my clients to think about their estate plan every 3 to 5 years. It may not mean that they actually make an appointment with me and take the time to review it. But darn it, I want them to do it at least 10 years.
Yes.
Because there's probably major changes in the law or in their life. But triggering points that really should make them come in earlier than 10 years, if that client became married or if they divorced, or if the client, they're in a domestic partnership and they want that partner to be taken care of in their estate, but also if there's a domestic partnership, I probably want to have a cohabitation agreement as well. So there's more to estate planning than just wills and trusts and powers of attorney and advance directive. There's other pieces to it too. If their child has died, or if their children develop a substance abuse problem, or grandchild has a substance abuse problem, or if a grandchild is born and has special needs, or if their named fiduciary is no longer around, has passed away, or if they have named their own sibling and the sibling has also matured and is no longer an appropriate person or to do that type of work. There are reasons why an estate plan needs to be updated, and those are the key factors. The other one is if you're a business owner and you think you're ready to sell out or retire, if you can think about this 5 years in advance, talk to me, because there's some work, due diligence to do in getting a business ready, getting the tax returns ready, getting the corporate documents ready, getting valuations on the business ready. Also to think about how will it sell? What's that structure look like? How is that money? Is it going to be a big chunk at once? Are we going to look at gifting some of that money to reduce the impact of the income coming in? It depends on the scenario when to come back to me.
So Anastasia, this has been wonderful. Obviously, people are going to have questions. How can they get a hold of you?
They can find my contact information at my website, which is aymeisner.com.
Thank you so much for helping out and being a part of the Chamber of Commerce and everything you do. Sounds to me like you kind of help the little guy out there, and I love that. And as I always like to close the show, don't forget, every day is a Chamber of Commerce Day here in Lake Oswego.
The Lake Oswego Chamber of Commerce thanks you for listening to Business LO. We would love to have you as a member so you can help Lake Oswego continue to be one of the best places to live, work, and play. If you want to share an idea for a future episode or become a member, visit us at lakeoswegochamber.com, and please like and follow us on Apple, Spotify, or wherever you get your podcasts. And for help with your business podcast, go to modcastproductions.com.